New York City, can you hear us?
Yes. Yes.
Great. We're going to get started. I know that we're waiting for a few of our members to arrive, and in fact, one of us has just joined us. But I thought maybe some of these preliminary matters we could start on them, and hopefully that'll give them time for the others to arrive and join us. So welcome, everybody. I appreciate the tremendous turnout. This meeting always has a very reliable turnout among the board members, and that's a very positive thing. I'm going to turn first to the first matter of business, and that is review and approval of the meeting agenda. You all should have gotten the meeting agenda 2 weeks ago. Kathy, have there been any changes on the agenda since it was sent out 2 weeks ago?
No changes to the agenda. We have updated a few, a chart which we just handed out, and it should be also in New York City, as well as we got 2 updates on letters from Lab Disclosure, as well as the letter from Jack Valentine.
And they should all be available to you in the city as well as at your seat. But with no changes to the agenda, is there any proposed by any of the commission members? Hearing none, could I get a motion to accept the agenda as proposed? Dr. Stajic made it. Gina Bianchi made a second. All in favor? Aye. Opposed? All right, that carries unanimously. The next item is the review and approval of the meeting minutes of the June 17th meeting. You all should have received that in the mail as well 2 weeks ago, at least. Is there any suggested changes or deletions from the meeting minutes? Hearing none, can I get a motion to accept the meeting minutes of the June 27th meeting? So moved. District Attorney Fitzpatrick, seconded. Dr. Stajic. All in favor? Aye. Opposed? Very good. At that point, we're going to move to the accreditation issues. And the first matter is the Suffolk County Crime Laboratory. Dr. Gemma is here, I believe. Can you join us here? Yep. Okay. And Kathy, can you walk us through that?
Yes, this is a mid-cycle inspection. The inspection occurred October 26th to 29th of 2010. And in your packets, you have also got a binding recommendation letter from the D&A subcommittee. Also, you have July 1st, 2011 letter from Allelic Lab granting the reaccreditation of the Suffolk County Lab. And there were a number of things that needed to be remediated, and all have been. And it said there's it's a mid-cycle inspection. I don't know if you have any questions, but Bob Jenna is here if you have any specific questions on the report.
This relates to another matter, but the laboratory is accredited in controlled substances, correct? The laboratory is not accredited in toxicology?
The crime lab?
Yeah.
No, toxicology is separate.
In a separate laboratory. The crime lab does not perform blood alcohol analysis.
Correct.
Okay, thank you.
Any other questions for? Yes, Marvin.
I had a few questions referring to the Allelic Lab report, and specifically page 22 of the Allelic Lab report, as well as page 23. My question refers on page 22 to the issue of testimony by examiners in the laboratory. And I see there was a remediation in that area with respect to 2 of the examiners. So my question simply is, at this point, how do you conduct and what records do you currently keep for testimonial documentation, and do supervisors in the lab review testimony with examiners both before and after they testify in court?
We review testimony in accordance with the having an individual who is qualified in the same field attend the testimony of the analyst. We try to get a supervisor, but if we can't, we send somebody else who's comparable. We then write the review, leave it with the quality assurance manager that's kept on record, and we keep records of each one of the people who testify and those that don't testify, so we can afford those records.
Okay. Let me turn your attention to page 23 of the same ASCLD lab report with respect to a remediation on document examiners, where the examiner in the question documents area, it turned out that there were 2 individuals involved in the document examination, but only one signed off on the form. How did that come about? It appears you've corrected it, but I don't understand what happened there.
Talking about the proficiency test of 2009,
Yes.
that's an item that we covered at a previous meeting. We discussed that in detail. There's only one question document examiner in our laboratory, and we met and discussed that in detail at previous meetings. I'm not sure I understand your question.
Well, it says the examiner reported the probability that all question handwriting was from a single person when in fact there were 2. Does that condition still exist? Where there's no more 2 involved, only 1?
Dr. Corrado wants to mention something.
I think I'm just trying to clarify your question. This is relating to the 2 examiners that the test indicated there were 2 different people writing it. It wasn't that there were 2 examiners in the laboratory. Does that clarify?
Right. Yes.
Okay.
That's it for my questions.
Okay. Any other questions for Director Gemma? Hearing none, can I get a motion? Or, I'm sorry, this was a mid-cycle inspection, so we don't have to approve this one at this time. Thank you very much. Appreciate it.
The next laboratory is the Nassau County Office of the Medical Examiner Forensic Toxicology Laboratory. This is also a mid-cycle inspection, and they had their inspection February 8th to the 10th, 2011. And there's a letter in the packets of the binders dated September 29th from ASCLD Lab granting reaccreditation for the toxicology lab through September 10th, 2013. They had just a few essential no's, one of which they appealed, which is, and I included all of the documentation regarding that appeal in the packet, so you get a little more information on this laboratory. And they did lose the appeal and had to do corrective action on that issue. The lab director, Dr. Joe Lavilla, is here, and he can address if you have any questions.
Okay. Any questions for Dr. Avila? Hearing no questions, can I get a motion? Oh, I'm sorry, we don't need one on this one either. This is a mid-cycle inspection as well,
Yes.
so thank you, doctor.
I'd just like to add one thing. The laboratory has been preparing and is accredited to do human performance or BWI toxicology. We expect to undertake that testing within the next few months, and we just wanted to inform the commission of that so that they take it under their advisement.
Are you accredited in that at this point?
Yes, our accreditation covers that area.
They have broad accreditation coverage on forensic toxicology, so they're just bringing in, they've already reached out to ASCLD, there's nothing else they need to do. It's just more of informing the commission that this is something they're taking over.
Thank you. Next matter is the Erie County Department of Central Police Services Forensic Laboratory.
This is a request from the Erie County Department of Central Police Services Lab to extend their provisional accreditation in the trace evidence subdiscipline areas of fracture and polymers duct tape. They have previously had accreditation from September 15, 2010 through September 14, 2011. OFS notified them that, in order to continue doing casework after that date, they have to receive provisional accreditation, an extension of their provisional accreditation. You will note also that in the meantime, they have received their accreditation from the ASCLD lab, but we are not voting on the total accreditation at this point because the DNA has to be reviewed by the DNA subcommittee. So really, we're just going to be voting on the extension of accreditation, which would just cover through to our next meeting in December when we can vote on the whole package.
Is the lab director here?
Yes, the lab director is here. Dr. Simich?
There's this explanation that something about an inadvertent deletion from the application, this category for which you're seeking provisional accreditation?
Yes. In 2008, when we were due for reaccreditation, I left it off the application. So ASCLD lab did not audit those disciplines. Subsequently, it was an oversight on our part. At that point, we requested that the commission grant us provisional so we can continue to do casework until our mid-cycle when we can get it added back onto the audit, which it was, and they did a full review and everything was satisfactory.
So in the most recent ASCLD review, this provisional category has been now reviewed by ASCLD, correct?
That is correct.
There's no mention in the documents from ASCLD lab. There is trace elements, but they're trace evidence, but there's no discussion of this sub-discipline. There are checklist items for the there's nothing here that says that's the case.
They include those subdisciplines under the polymer and general physical and chemistry things, but I know what you're saying. They do not specify because they don't do it as a provisional accreditation is not something they.
Yeah, it's very confusing. You provide these explanations, but there's nothing in the documents here that's. So we're to believe that everything's been fixed. You've applied to ASCLD lab. ASCLD lab has inspected the lab, and that at some near future time, next meeting probably, we will be voting on the full accreditation that will include this provisional discipline. Correct?
Yes.
And this is an unusual provisional discipline situation because you had full accreditation and it was really a clerical reset to a provisional situation, right?
That's correct.
Same analysts?
Same analyst.
And we currently have granted them
Provisional. No, I understand that, but we granted it. It's not the usual provisional where it's a lab that's not had accreditation,
right,
that wants to do casework without accreditation. This is an accredited lab that,
yes,
for clerical reasons, dropped their accreditation, not for technical reasons. They were continuing to perform the analysis with experienced personnel. The same personnel are still there, and the error will be corrected at the next meeting, right? Okay, thank you.
So any further questions for
I had some questions.
Yes, Mr. Schechter.
With respect to the duct tape, can you tell us, since the last time you were here, what the lab has been doing with respect to duct tape analysis?
It's a broad question. Can you narrow it down? I don't really understand.
Sure. Have you had any specific cases where you've had to analyze duct tape from crime scenes, make an analysis, reach a conclusion, report it to the district attorney's office, possibly testify or not testify in court?
Yes, we have.
Can you be a little bit more specific as to what kind of analysis you were asked to do on duct tape?
For duct tape, we are asked to examine the question material, compare that to a known sample of duct tape to see if they have the same characteristics, which would include looking at the adhesive, looking at the weave pattern, the outside part, the composition of the outside part of the duct tape, the outer layer of it, and seeing if the class characteristics are the same or different. And if there's a fracture match, we will also attempt to do a fracture match on the duct tape. That's not always possible. It's probably a less common event with duct tape.
with respect to doing the fracture match, have you done any of those?
On duct tape, I don't
Yes.
recall specifically every case. For duct tape, I do know we have had a duct tape fracture match possibly a couple years ago.
But not under the
Doctor,
provision period.
I don't know if it was or wasn't, to be honest with you. I really don't recall exactly when that happened. It's been a while since we've had a fracture match duct tape. Like I said, it's not that common where we have one.
the problem that I have with this particular accreditation in duct tape is that everything that I've read about duct tape suggests that there are no studies that permit a scientific investigation into duct tape other than to declare that the duct tape is a class characteristic. And with respect to duct tape, at least in the United States and Canada, there are but 3 or 4 manufacturers nationwide. And so my question to you is, what is it that you're going to get from this duct tape accreditation? And to be more specific, I see this as a real abuse of the accreditation process, because it takes what may be a non-science, a discipline at best, and gives it the imprimatur of credibility when one of your technicians takes the witness stand and says, this piece of duct tape found at the scene matches the piece of duct tape found in the defendant's home. And I'm not talking here, I want to be really specific, I'm not talking about hair analysis off the duct tape, I'm not talking about fingerprint analysis off the duct tape, I'm simply trying to get at the ability of your technicians, if we give you this accreditation, to take the witness stand and say, I work in a lab that's been accredited in duct tape analysis, and here is my conclusion. And it seems to me that it's almost akin to saying I found water at the scene of the crime, we went to the defendant's home, and we found water. What's the difference? What studies can you point to anywhere in the world, not just the United States, that allow you to go beyond a general class characteristic to say the duct tape at the scene is the same as the duct tape found in or near the defendant?
Our analysts will testify that they performed the examination of the various class characteristics that they were able to identify, and they're either similar or they're not similar. And they'll give the appropriate testimony exactly to those findings, and also include that it could be this roll of duct tape or any one manufactured of the same lot number, basically. That's duct tape is absent a fracture match, it's a comparative science, as many trace disciplines are.
So at best, what you have when you do that, and you testify as to class characteristics, is you have something that may be relevant, piece of scientific evidence and scientific in quotes, but it may not have any probative value whatsoever. What would be the probative value of your technician saying in a court of law that I did this comparison and I found that this duct tape found in the defendant's home and the duct tape found at the scene were manufactured by the 3M Corporation? Is it then up to the defense and the counter-arguments in the courtroom to show the jury that although your ASCLD lab accredited in duct tape analysis, that therefore your evidence has some meaning? Is that what we're going to do here today if we extend you this accreditation?
The doctor really isn't qualified to talk about the probative value of evidence. That's an argument for the courtroom.
I would normally, I'm sorry. Normally I would agree with the chair, but in this case, this particular piece of evidence has some kind of probative value. It is forensic, it is science. So to me, I'm trying to find out what the technicians are going to say if we give them this accreditation. Will they be limited to saying, doctor, that all we're testifying to is the class characteristics?
If that's all they find, then that is exactly what they will testify to. And the trier of the fact then determines the weight they give to that evidence, given the other evidence in the case. That's the whole premise of forensic science.
I have a follow-up question then on that, which is that in a case where there's no fracture comparison, and you're actually simply comparing class characteristics. Does your laboratory have any databases at all on the frequency of those class characteristics that you're comparing?
No, not productive.
So if you don't have any frequencies at all, any databases at all which would reflect the frequencies, either the rareness or commonness of a particular class characteristic, how can we validate for court a methodology where people will imply certain probative value by the mere fact that a person walks into a courtroom with a lab coat and says that the duct tape found at the scene and the duct tape found in the defendant's home have the same class characteristics if the finder of fact has no idea as to how common or rare they are?
This is not the only discipline where this occurs in, and it does occur, and it has to be qualified properly with the questions from the prosecutor and from the defense in hand. If they ask the proper questions, they can, assist the trier of fact in assigning weight to this evidence.
But in the absence of questions being given to you by a competent prosecutor or a competent defense attorney, are there any requirements in your protocols in your laboratory that mandate that when an individual testifies to class characteristics only on duct tape, that they offer proactively, whether they're asked about it or not, the extraordinary limitations of that testimony, given to wit that you have no idea on the rareness or commonness of those class characteristics? Is that done automatically by the people in your laboratory, whether or not they're asked those questions by lawyers?
If you're not asked a question, you frequently cannot get that information into the court. You can't just start running off and explaining things. If the question isn't asked properly, you're going to get objections, and it's really not the role of the forensic scientist. If the question's asked, it will be answered accordingly. That no, we don't have a database and we cannot give a statistic on it, and I doubt that we are the only ones who do this.
So I walked in late on this discussion. I apologize, but I can tell you, in light of the NRC report, that, and not just the NRC report, but the comments that have been made by lots of judges and law professors since, that if you want to be accredited to have somebody go into a court of law wearing a lab coat to suggest that there is some probative value to a comparison of class characteristics where you have no idea and do not testify as to the rareness or commonness of those class characteristics, I would be opposed to any kind of accreditation in that discipline, that we would be remiss if we even allowed that kind of thing to go forward. I haven't heard this before, but just having heard what I just heard in this exchange between you two, I am actually dumbfounded by that.
I mean, and I apologize because I really am not a trace examiner, unfortunately, and I really have not seen databases with that information. I don't know if they exist or not. If they do,
I appreciate your candor.
You don't use them.
Any more questions for Dr. Simich?
Voting on
Yes,
the
Judge.
In the last 2 years or so, how many such tests? About
Erie County.
I think less than 5. We don't see a lot of duct tape where we do comparisons on.
Any further questions for Dr. Simich? The only matter that requires a vote is the matter of the extension of the provisional accreditation to extend the currently existing provisional accreditation through December of 2011 so that the process can be completed and reported out at the next meeting of the Commission on Forensic Sciences. Do I have a motion in that regard? Yes, Dr. Corrado.
Yes.
Dr. Corrado, what's your motion, please?
To extend the provisional accreditation for Erie County for polymer and duct tape analysis.
Okay, correction. Okay, and
I have
Mr.
an alternative motion. I have an alternative motion. I'd like them both to be heard at the same time. My motion would be that unless and until we receive additional information from the laboratory that they have those kinds of databases and frequencies, or that we learn that their protocols are such that they affirmatively, proactively, without district attorneys or defense attorneys asking, explain that we have no idea how rare or common something is, that we actually decline any kind of accreditation until such time.
Okay, so Mr. Neufeld's motion is to propose not to extend accreditation at this point of the provisional, not to extend the provisional accreditation. Since we already had a motion on the floor to extend it, is there a second to the motion on the floor to extend it?
Second.
Dr. Stajic. Further discussion on the motion. And Mr. Neufeld, should the motion go down, we would then consider your alternative motion, which is not to grant the provisional extension.
Although I guess my motion is moot if the other motion goes down, I would then modify it if their motion goes down, that we make an affirmative requirement that they present to this commission whatever databases exist and suggested protocols for what would be appropriate testimony given the obvious limitations of this type of forensic test. So I'm sorry. So to be perfectly clear, I withdraw mine for the time being, and depending upon the outcome of this vote, I will then renew it.
Thank you. Dr. Jenny.
Well, I would only comment that, Peter, if you moved to deny accreditation, wouldn't you have to apply that systematically to all laboratories that are presently accredited? You can't single out one and allow others to continue.
Why? We haven't heard what the other laboratories do. Maybe in those laboratories they have a protocol where proactively the examiner explains to the court and jury that we have no databases. We can't tell you how rare or common these class characteristics are. So that's all we're telling you. I mean, I don't know, but we have this. In other words, in courts, generally, the only reason they make decisions if there's a case in controversy. Right now, those other laboratories aren't in front of us. This one's in front of us. This issue is ripe, and therefore we can decide it. It may very well be that as a result of this vote, we could decide to take up as a matter of new business at the next meeting the bona fides of this discipline in terms of first principles. But certainly, based on what I've heard today, I could not in good conscience accredit that discipline, based on what we've heard.
Any further discussion on the motion? Hearing none. All those in favor of extending the provisional accreditation for fracture matches, polymers, and duct tape for the Erie County Central Police Services Forensic Laboratory through December 31st, 2011, please indicate by saying aye.
Aye.
In the city, could you raise your hands? Okay. Opposed? Okay. So the vote was abstained? 9-3 in favor. So the motion carries. The provisional accreditation is extended through December 31st, 2011. Thank you very much, Doctor.
In light of the fact that passed, I would ask that you add to the new business for next time that we actually have a substantive discussion about duct tape class characteristics to find out whether or not in New York laboratories they do have databases, whether they have any kind of protocol requiring their analysts to disclose proactively the extraordinary limitations of their testimony and related issues.
Will do.
I mean, because right now we're putting this commission is giving the same imprimatur to the duct tape that we give to DNA, and I think we know very little about it, and I think we would be remiss if we at least didn't have a discussion about those kinds of scientific issues that I'm raising.
Fair enough. I happen to know that the December meeting is going to be a very full one. We will try and fit it in new business, but if the number of hours that we anticipate the meeting is going to be, we have a list of things that have been requested that we always get to, and we always put them in new business. We'll get to it, hopefully in December, but if not, thereafter.
And
Okay.
I would agree with Peter, but I think it would be important to include in that review the basis on which ASPAD Lab has determined that this is an acceptable forensic subdiscipline.
Okay.
It might also be a good idea, Mr. Chairman, if we could find out along lines that Dr. Janney commented upon, how many laboratories here in the state of New York under our jurisdiction are currently accredited in tape analysis. I don't know how we would do that, save for sending a letter to the different labs and asking them.
We'll try and find that out for you, Mr. Schechter, as well.
I appreciate it. Thank you.
Okay. The next matter we have before us is the Onondaga County, Westchester County Department of Labs and Research, Division of Forensic Sciences.
This is a request for an extension of accreditation for the laboratory. They're requesting a 6-month extension, which will cover their extension received by ASPAD Lab International through March 29, 2012. They require this extension because in the ISO program, once you end one of your accreditation cycles, you don't continue on with the dates, but you get new dates for you finally get voted on. They applied for accreditation back in December of 2010 and just had their inspection in September of this last month, and it'll be a few months before they can, call for a vote. So we just need that extension to cover those dates, the gap of dates. Bob Adamo is the lab director, and he's here.
I move approval extension. I think it raises a question about the resources of ASCLAD that an application received in December resulted in a scheduled survey 9 months later. But I don't think, unless that was an issue related to the lab's resources, no, it was ASCLAD Lab's untimely response. But for purposes of the extension, I would vote for approval.
Any second to that? Dr. Stajic seconded it. Any discussion? Hearing none. And all those indicating support for the motion to grant the extension for Westchester County Department of Labs and Research Division of Forensic Sciences, please indicate by saying aye.
Aye.
All those opposed? One. Superintendent D'Amico, are you opposed? Or?
Not opposed, just delay on the video.
Okay, sorry. And any abstentions? All right, it carries unanimously. Thank you very much.
Are we aware of any other serious lack of response from ASCLAD?
I'm not aware of any.
Nor am I. I think I was reading their materials today, and they asked for a year in advance.
But with their new program, they're not going to, the lab did what it was supposed to do, a year in advance and
Yes.
send in its application.
Yeah. I understand.
That's not going to work if they don't get to them for 9 months.
Onondaga County Center for Forensic Services. What we have is a letter dated September 28, 2011, granting continuation of accreditation following a surveillance visit that was performed on September 8, 2011. Obviously, Dr. Corrado is here and available to answer any questions if anyone has any. Yes, Mr. Neufeld.
On the review of the annual report, which is page 2 of 5, it says under the 6th bullet that the laboratory provides information concerning 3 non-conforming work events and 1 substantive corrective action which have occurred since the last visit. Could the doctor please tell us what those are?
I can tell you that those have been provided to this group previously. The substantive corrective action, if you remember, that was the instance where we had the sight post that was lost from the, fell off of one of the long rifles that we had, and it was discussed here previously. The other non-conforming work events, I honestly, off the top of my head, don't remember. Those were all reported to you with the annual reports that we provide. If you'd like, I can bring those back to you at the next. Basically, they're looking at things that happened the year before, so now we're looking really 2 years. So these are things that happened quite a while ago.
No, I appreciate that, and I'm not asking you to give me something new. Just as you can't remember them, I can't remember them. If at some point you could just sort of send me something which reminds me of what it is you've already shown us, I would appreciate it.
I mean, yeah, these were things from 2009, and given that they're non-conforming work events, they did not go to corrective action. They're essentially very, very minor things that we self-reported as a preventative or something that we looked into that we determined did not require a corrective action. But I can look those up and get back to you.
Did we, I'm sorry, Doctor, did we also get a printout of the nature and extent of the corrected action?
You did.
At a previous meeting?
Yes, you did.
I guess that would be the only one I need to be reminded of. You're right. The other ones are minor. If they didn't rise to the level of corrective action, I don't need to see those, but I would like to see the other one again.
I'm sure we can get that to you.
Yep.
Yeah, we have.
Thank you.
They'll get it and circulate it to all the commission members. Dr. Jenny.
For my clarification, this review of annual report, this is a form letter, correct? You may not have had, in fact, 3 non-conforming events. So is this customized to your laboratory?
It is customized. I mean, what they're doing is they're reading our annual report. So they came to us in 2011. Our annual report that they're reviewing is what we did in 2010. So it's basically, we're reporting on what we did the year before, then they're reading that annual report, and it is customized. They look through any substantive corrective actions we have, as well as what we reported in our annual report.
Any further questions for the doctor? No vote is required on this matter. The next item up for review is the New York City Police Department Laboratory.
This is also a surveillance visit report, occurred August 17th through the 18th, 2011. And so there are really no issues associated with this as well. We do have Dr. Scott O'Neill here to answer any questions, if you have any.
Any questions for Dr. O'Neill on the surveillance visit report? Hearing none, this does not require a vote, so we'll move on to the next item, which is the Nassau County Department of Forensic, which is new business, by the way. We're turning next to new business. Dr. Pasquale Balfino is here. He's going to provide us a preliminary report on the work of the status of the new laboratory. Just let me also, if I could, remind you that this matter is still under investigation by the Office of the State Inspector General, and so I would keep that in mind when making your comments.
Correct. So basically what I wanted to discuss, just to inform the commission members, the status of the new laboratory, and to also go over a second front that we've been working on in the interim of the new laboratory, which is scheduled for sometime mid-2014, end of 2014. So currently we've conducted a feasibility study, which has been accepted, and we're in the process of
the design phases right now at this point. So we've had a lot of support from the county executive, Department of Public Works, and we're moving pretty rapidly on the designing of the new laboratory in the Public Safety Center of Nassau County. So again, as we're looking at sometime within 2014 to open the doors of the new forensic laboratory. While this is occurring, one of the requests by the Police Department, District Attorney's Office, and the county executive was to get a civilianized latent print unit up and running. We have a time frame for that. At first, we were looking to get the comparison portion of latent prints up for February of 2012, and we are in great shape for that. We've gotten some space in the S building right next door to the medical examiner's office, where we've put a secured laboratory with instrumentation for latent comparisons. Our date for SABIS install is sometime in December, training in January. And the only thing we're waiting for on that particular issue is sometime in January, we're looking to get on the executive session at the state ledge to get us qualified, as Onondaga had done several years back, to categorize us as a qualifying agency. About 2 or 3 weeks ago, we were also asked to get processing for latent prints up and running too. So we're trying to identify more space, and we're in the process right now. We've given approval to hire 6 more examiners on top of the 2 that we have now in order to handle the processing and comparisons and verifications for latent prints. And what we're looking at with that is hopefully sometime by February. Right now, all of the latent groups SOPs, they're completed. I'm in the process of reviewing those. We have them up on the laboratory information management system. So again, the only thing we're waiting for is to submit an application, and by the December commission date, we're going to be coming here and hopefully requesting provisional accreditation for the interim of waiting for our ISO inspection in latent prints. And that's where we stand at this point now.
Any questions for the doctor? Please, if you do, I ask you to be very circumspect about your questions because of any ongoing investigation by the OSIG. Dr. Carrano.
I have a question. I'm just wondering, have you been given any information relating to, will the police agencies in your county submit their latent print evidence to you? Or are they going to also continue to submit to the Nassau County Police Department latent print unit? Are you both going to be operating, or will there be direction given to submit just to your laboratory?
At this point, 2 weeks ago is when we were told that the interest was to have both processing and comparisons. So we were going to have the existing latent unit process. We were going to handle the comparisons and verifications, which we're currently sending to Sergeant Dowd's laboratory in Westchester. The plan now is to have a complete civilianized laboratory that will process, so the evidence will be submitted directly to the medical examiner's office.
Do you expect there to be a directive to do that? I mean, you yourself can't force the police to submit to you.
No, we had a meeting about 2 weeks ago where the directive was given by the chief of police to members of that meeting, that it was everyone's best interest to civilianize the laboratory and have one agency handle the processing and comparisons.
Any further questions for the doctor?
Is Nassau County Executive in line with that program? Was there a representative from the Nassau County Executive at that meeting?
No, but not at that particular meeting, but the MOA for the SABIS unit was signed by the Deputy County Executive, and I did speak to the Deputy County Executive, who is on board with this plan of action.
Dr. Jenny.
You mentioned you are about to recruit 6 additional examiners.
That's correct.
How's the pool of candidate examiners?
We've got some people coming from out of state. The pool is actually is fairly good. But at the same time, I want to give a couple of young forensic scientists an opportunity to get into the field at a trainee level and bring them up from ground floor up. My latent supervisor, Jen Hannaford, has told me that there are a good amount of people who are interested with background in latent prints.
How's that number compared to the former laboratory?
We're going to try to do it with 8, and I believe the number in the former lab was 10.
Mr. Sheck.
I have a question about the fingerprints. First, Doctor, were you able to attend the program that was put on at the New York City Medical Examiner's Office where Dr. E.T.L. Dror presented the data about fingerprint methods and procedures as well as other methodologies for reducing the risks of cognitive bias in forensic assays?
No, I was not.
Okay. Are you familiar with the FBI procedures that are now in place for doing fingerprint examinations that they've come up with since the Mayfield case?
I am not, but I have a print examiner who is qualified for that. I'm new in this field of print exams, so I'm in the process of learning.
Right. The first what I would urge you to do is to first of all get a hold of the new FBI procedures on how to conduct fingerprint examination, which detail a method for first looking at the latent print before looking at the target print, for identifying on the latent print any possible so-called red flags or artifacts, for proceeding in a linear fashion in terms of looking at the ridge flow and other characteristics, and then after the examiner looks at the target print, to document any differences that may have occurred in the examination of the prints. In other words, anything that is now seen after looking at the target that were not seen when looking at the latent. In fact, it's a very, very detailed protocol, and it came out of, you're familiar with the Mayfield case, are you not?
I am not.
All right, well, you've got a lot of work to do.
I believe me, I do. Not just with latents, I have plenty of work.
Right, you might want to read the chapter in the National Academy of Science report with respect to fingerprints that detail the Mayfield case. This is the case where the FBI made an error in wrongfully identifying on a 16-point match a lawyer in Oregon as being the person that left a fingerprint on blue plastic that was used for the bomb that blew up the trains in Madrid. The Spanish authorities indicated to the FBI that they did not agree, and then eventually the Bureau came to agree with their assessment and then revised their entire set of protocols. And so I would strongly urge you, before you even start hiring personnel, or at the time you're hiring personnel, to make sure that you're familiar with that literature, and that I would strongly urge you to adopt the FBI's procedures and put people in place that are capable of doing that.
Okay.
Any other questions for the doctor?
I had one.
Yes,
You
Mr.
mentioned, thank you. You mentioned that you have hired somebody who's advising you on prints, latent prints.
2 individuals.
Can you tell us who you've hired so far to help you with this first phase of reorganizing Nassau County's lab?
Jennifer Hannaford and Andrew Rettenauer.
Thank you.
You're welcome.
Any further questions for Dr. Buffany?
A quick question. Are you changing your laboratory's name when you seek, after you seek original accreditation?
They're going to be separate. There'll be a Department of Forensic Genetics and a Department of Forensic Science until the new laboratory.
Any further questions for the doctor? Thank you very much, Doctor. Thank you. Appreciate the effort. The next matter that's on the agenda under new business is a discussion of provisional accreditation. This was a matter that was raised at an earlier meeting. The request was made that we put it on the agenda just to discuss it at a later meeting. And you all should have received a report from Accreditation Labs under new business that details its accreditation process. In addition to the Accreditation Lab materials, New York State, of course, has its own rules and regulations on accreditation. And part is covered there as well. Rather than me talking about all this, let me just throw it open for discussion.
I just wanted to add one thing. In the notes section, I had you refer to a few areas of that program outline. Also, page 22, extension of scope of accreditation is very pertinent to the discussion. And that's listed on page 22. That indicates that once a lab is accredited, they may elect at any time to begin performing work in a non-accredited discipline, as long as they don't infer that they are accredited in that discipline or category of testing. So as far as ASPA is concerned, they are perfectly willing, it's able for a laboratory that's accredited to bring on disciplines as needed.
But their process seems to explain is that a quality system exists in an accredited lab, and if you undertake an area of work that you haven't received accreditation in, you have to do it in full compliance with all the quality standards, and then at your next annual surveillance cycle, you must seek full accreditation in the new discipline at that point. At no point prior to you receiving full accreditation can you represent to anyone that you are ASCLAD certified in this particular forensic concentration.
When we raised this discussion before, it was largely because I believe prior to this amended 2010 document, ASCLAD labs expected labs to have performed real casework prior to their initial survey. And therefore, a lab had to come to us for provisional accreditation in order to perform that real casework in anticipation of seeking ASCLAD lab. ASCLAD lab now apparently offers them the option that in a state that requires state accreditation in order to perform real cases, they may now perform 5 mock cases in the discipline, which would not require our provisional accreditation, and use that data as the basis of their accreditation request to ASCLAD lab. So that it doesn't say they have to do that, it just says that's an option. So if a lab wanted to use real casework for their ASCLAD lab accreditation, whether it's a new discipline or it's their initial discipline, they have to come to us to get provisional accreditation in New York State. If they want to use a mock case alternative that ASCLAD lab now offers, they would not have to come to us. They could get it their accreditation, which may be to their advantage. But it suggests, since ASCLAD lab still allows an existing lab to take on a new discipline using without even telling them, basically, in that circumstance, in New York State law, they still have to come to us for provisional, whether they're going to use real case, if they're going to use real casework. If they were going to use mock casework, they wouldn't have to come to us. So the conversation we had had before about provisional was not that labs don't have to do something in order to get ready for an inspection and accreditation. They have to do casework. But if they were going to use real casework, which appeared to be what ASCI Lab expected them to do, the question was whether there should be a disclaimer on any of that casework, whether there should be a requirement from us regarding a provisional permit that says if you have a provisional permit, you must include a disclaimer that says this testing was done under a provisional rather than full accreditation, and or whether parallel testing, repeat testing in a duly accredited lab of all or some proportion of that casework should be required. You know, whether our provisional accreditation had to have additional, because it's really moot as to what ASCI Lab's requiring, because they haven't looked at the lab. They haven't looked at the lab's methods. We haven't looked at the lab. We haven't required submission of methods. We based it simply on the presumption that they will be seeking ASCI Lab, so they will be working on appropriate methods. And I'm not questioning the strength and value and, you know, professional commitment of any of our existing lab directors. I'm sure they all do that. I'm only questioning on what basis the commission can decide the lab should proceed as an accredited, be it provisionally accredited lab. And I think it goes to some of the comments that Mr. Schechter made earlier about how do you know, how does the lab make certain that everybody knows? The informed DA and perhaps the less informed pro bono public defender about the status of the laboratory's validation of their ability to offer some new discipline. So I think it's great. ASCI Lab has recognized that the use of mock cases might be an alternative for a lab in which to do a real case you have to have a state accreditation. But I don't think that completely removes the need for this commission to consider whether we in New York want to have specific requirements for the issuance of a provisional permit or accreditation. And that's why I made the point earlier about, I think it was Erie County, you know, they were an accredited lab, they were continuing to do something for which they were accredited. I think that was a slightly different circumstance than Nassau coming to us in December and saying we want a provisional permit because we want to start doing print analysis in January with newly hired technicians in a laboratory that is really a new lab that has not previously performed any forensic analysis in a discipline that is an established discipline, but it's a problematic discipline. So if we give them a provisional permit, are we going to say, yes, but all your reports must say this testing was done under a provisional permit? If we give them a provisional permit, must they seek technical review of some percentage or all of those analyses? And onerous, I'm not, you know, or should the lab be told, no, go away and do mock cases for 6 months, get your accreditation from ASCI Lab, and then come back? Problematic also because of the resources of the county. But I believe that was the basis of wanting to have the discussion.
Dr. Corrado.
I just want to clarify one thing that you said initially, because I'm not, you might be correct, but I'm not sure. I think with ASCLAD, they allow you to do the 5 mock cases, like Dr. Willie said, and I think you may elect to apply to have that new discipline reviewed at your next annual surveillance. But I believe the way I read it, and obviously we can ask them for clarification, I think you're not obligated to have them audit that for ASCOD Lab until your next full accreditation audit, which could be, well, whenever that is, you know, at most it would be 5 years. So I think we just need to make that clarification that it's what we could discuss. Would it make sense perhaps to have the labs require them to request it at their next annual surveillance, something like that? But I don't think that ASCOD Lab requires it. The second thing that I would just like to bring up in terms of the discussion is it's not clear to me when I read the executive law that it's even required for the laboratories to obtain provisional accreditation in any discipline or sub-discipline if they're already accredited. And obviously, I'm not a legal person, but I'm not sure that the current executive law specifically states that it is required unless you're a brand new lab that is unaccredited. And I think the last thing I would just like to say is that because this particular commission meeting occurs prior to the NIPAC meeting, we typically have our meetings before the commission meetings, but we weren't able to do that because this meeting was on a Monday. So the lab directors have not had a chance to discuss this at all, and I would like to make a request that we allow, before any decision is made, we allow the lab directors to discuss it and perhaps, write up something that we can offer our opinion as to how we feel some of these things might be addressed.
And while I would agree that the statute is not clear, by precedent, we have required that an existing lab adding a new discipline seek provisional accreditation.
Right.
So I do believe we've established that. A lab could challenge, but...
Any further discussion?
I have a question. I'm trying to understand right now if Erie County has already told us, for example, that they are conducting live duct tape cases and they have a provisional accreditation. Does that mean that when their examiners go into court and testify, that part of the limitation is they must state affirmatively that they are provisionally accredited by the Commission of Forensic Science of New York State, but not ASCLD Lab?
No.
No, I don't think so.
We've not set that as a requirement. If asked, they would have to say that, but we don't require that. And so their report that's generated to the DA or copy given to another party does not say that.
What I read in the ASCLD standards, Mr. Schechter, is that they affirmatively cannot say that they are accredited or provisionally accredited by ASCLD Lab in a field that they have not received full accreditation.
But
By ASCLD Lab.
Right.
But what you'll see happen, because we see it with clinical labs, the lab will say they are New York State accredited, which may well be true. They're not saying they are or they aren't in some new discipline. And we have to call them on that sometimes, but I don't know unless there's an enforcement. Erie County is accredited. They're not yet accredited in that discipline. So they aren't affirmatively saying, I'm accredited in duct tape. So it would be a fine line.
I'm just trying to get a sense of timing here, Mr. Chairman. How long ago did we put this on the agenda for? This provisional topic? I think it was at least 2 meetings ago.
2 meetings.
Yeah, I think it was 2 meetings ago.
I thought it was last.
Right.
So there's some view that it was last meeting. I don't.
It's in the minutes for the last meeting.
Oh, it's in the meeting.
I mean,
And it just says it was asked to be put on
All right.
there.
The minutes of the last meeting say it was asked to be put on the agenda, so it was last meeting.
my own feeling about this is that we ought to require in the state of New York, regardless of what ASCLD Lab's requirements are, that any laboratory seeking to do live casework in a discipline for which they have not been accredited must get provisional recognition from this commission. Period. And that if they someday get it from ASCLD Lab, that's wonderful. If they don't, they still have to abide by this commission. I am reminded that Mr. Keaton and Mr. Jarvis, during their presentation to the commission, indicated that they, of course, would abide by any rules and regulations that a state has with respect to anything having to do with labs. It is a little curious to me that in making the change and aggressively coming up with an alternative, i.e. mock cases, that they did not include a clause affirmatively saying, except in those instances where a state authority commission requires provisional or other accreditation to do live casework. So my own feeling is that's what we ought to do. Now, I'm mindful of the fact that Dr. Corrado has asked that the laboratory directors be informed about this discussion. And I think the best way to do that is to have the chair send a letter to the laboratory directors telling them, this is what we're thinking about, we're talking about this, could you please weigh in with your opinions so that we can hear from them in writing or in formal oral presentations at our next meeting or the meeting thereafter, how they feel about provisional status for live casework in a discipline where they are not accredited. Then we can collect all of that and we can have the discussion on what we should do in terms of proceeding forward. But as for me, and not being disrespectful to these lab directors, it seems to me, in the name of transparency and good science, nobody wants labs in New York State doing live casework in something that they are not accredited in, even provisionally, and presenting that result of their work in testimony sworn in a court of law against a putative defendant.
Dr. Corrado, when is the NICLAC's meeting?
NICLAC is meeting tomorrow, and we did put it on the agenda when we saw it was on the commission agenda. That's why I was asking if, the lab directors definitely want to look this over, because I think that we agree we want to make sure things are done properly, but I think there's some issues that might not be as simple, such as, what is considered a sub-discipline. I mean, that kind of thing has to be worked out and decided up front, I think. And so I think that those are some of the issues that we would like to discuss and work out and offer, as you suggested, offer our opinion as to how we feel this could best be implemented moving forward.
Dr. Willey.
And to comment, Ms. Schechter, historically, our issuing a lab a provisional permit, if you were to go and say, to make it absolutely clear, you want to add a new discipline, you have to have a provisional accreditation from this body, right? But our issuance of provisional accreditation is simply based on the fact that the lab asks for it. We review nothing. We don't look at the procedures to be used. We don't look at the personnel to be used. We rely on the lab director saying, I'm ready to do that. And I'm not questioning that a lab director would not ask if they weren't ready. Understand that. But we don't look at anything technical. We don't have the technical standards to do that.
We actually do ask for SOPs.
Okay.
In the
Gina may, or you may get it. We don't see it. Do we see the actual procedure manual that the lab intends to follow?
Competency tests, work charts, standard operating procedures, the training manual.
We don't see them.
I don't see them.
The last few that have come, I know earlier we have, and I remember when Westchester added digital, because I remember reading through the training.
We did ask them for that time.
But we generally do. You wouldn't see it for Erie because this is an extension. So
Okay, but we may be looking at those things. If we feel competent to review that.
Well, it's not a question of whether we personally feel competent to review it. We are more than capable of bringing in experts who can share with us an opinion as to whether a particular methodology in a new discipline is reliable and make some decisions about it. That's certainly within our authority. And the truth of the matter is that we should be exercising that more, certainly with respect to new disciplines and with respect to old assays which have been called into question by the National Academy of Science. I mean, we're under no illusions here that all of this is going to remain static. It is not. It's all changing. I think it's I didn't want Ann's remarks to in any way imply that even though historically we have just ordinarily accepted, yes, when it comes to toxicology, drunk driving, DNA, and many other disciplines. We didn't ask to look at the SOPs, et cetera. But I certainly think with respect to some of these pattern disciplines which are subject to question, we're beginning to take a much greater interest, and that's long overdue.
Well, I just wanted to add to Dr. Willey's comment that in addition to asking the lab directors under this provisional concept for the protocols, the manuals, the training, it would give the commission the opportunity to examine the databases, the scientific studies, and other information that go beyond just protocols and standard operating procedures. This is the second time in less than 6 months where we've had this issue rise on the whether or not the particular discipline has some scientific basis in terms of validation and studies. The other one at the last meeting was glass, where we had a presentation that we're going to have a discipline on glass comparison without any analysis, without any knowledge of the scientific studies. Today we had one on duct tape, and I thought that the doctor who presented on that and answered our questions was extremely candid and honest, and it made it clear to everyone that you need to have some better basis for evaluating these things before you accredit them. So yet another advantage to this provisional accreditation would allow us to go beyond the normal, to hire people or bring in people on a pro bono basis to examine some of these particular so-called disciplines and give us an opportunity to try and convince the majority of the members who don't seem to be accepting of these changes and who believe that static is the way to go, that this would allow us to change that and to put us ahead of the curve in forensic discipline changes and not behind the curve.
At this point, we have a request by Dr. Corrado that the NICLAC Advisory Committee be given an opportunity to consider and comment back to the Commission on Forensic Sciences their views about provisional accreditation. And we have at least Mr. Schechter and Dr. Willey suggesting that that would be something that we'd like to hear. Dr. Stajik.
I was going to say the same thing. I think it's very important that we get the input of the lab directors. So I would like to support Dr. Corrado's request.
Okay. So I don't think...
My only amendment, Mr. Chairman, my only amendment to that is that this request to hear from the lab directors be prior to the next meeting of the Commission on Forensic Science.
We're meeting tomorrow, so I suppose that we would get the results of that meeting. I mean, there is plenty of time to submit the responses, right, Kathy, before the next commission meeting, which is
certainly
December 8th.
That's the case, but I don't want to be here on December 8th and hear from Dr. Corrado that they're still in the writing process. So it might be a better idea if we were absolutely crystal clear that since their meeting's tomorrow, they obviously have enough time to present us in writing their views, that we have that prior to December 8th, and that be on the agenda, please.
Do I have a motion to refer this over to the New York Crime Lab Advisory Council? Ms. Bianchi, Dr. Willey seconded. Further discussion on a motion to refer the question of provisional accreditation to the New York Crime Lab Advisory Committee with a request, if possible, that they give us their views prior to the December 8th meeting of the Commission on Forensic Sciences. Quite frankly, actually, at least 2 weeks prior to it, because we need to enclose it in the mailing to all the board members.
Seconded.
It's been moved by Ms. Bianchi and seconded by Dr. Willey. Is there any further discussion? Hearing none, all those in favor, please indicate.
Aye.
Opposed? In New York City, if you're opposed, please raise your hands. Abstention? It passes unanimously. The next item of new business is accreditation expenditures. Following our visit by representatives of Askeladd Lab and their presentation to the commission, we sent out a letter to all of the laboratories accredited either by ABFT or by Askeladd Lab, as well as letters to Askeladd and ABFT, requesting that they provide full disclosure to the Commission regarding expenses incurred in the accreditation of their programs. Those materials are provided to each of you in your binder under new business. Is there any discussion? Hearing no discussion.
Sean?
Yes.
Well, I find the information very interesting and very worthwhile, and I do thank the labs, ABFT and Askeladd Lab. I think there's some interesting odd numbers in here that make me ask, so what did they include in their costs? I don't know what the labs got told to include, because if you look at their numbers versus ABFT numbers versus Askeladd numbers, they're not exactly the application plus the inspection. And of course, we didn't ask the PT providers, but it's very worthwhile information for the first time we've ever looked at fiscal information. I think it's striking that our labs are spending in excess of $250,000 a year total. I mean, that's rough numbers. If I take the averages of what each lab tells us they're spending and add up all the labs and all the accreditations, it's
cumulatively statewide.
Statewide each year,
right.
All the labs are spending together in excess of $250,000. The range is from $120,000 to $5,000 or $6,000.
Right.
But that's a substantial fiscal commitment to certifying, to documenting their compliance with the standards that are being set by the profession. I note that that's significantly more on average than what a clinical commercial laboratory pays based on revenue. I mean, they're making money and they're paying a lot less than this for their accreditation and proficiency tests. So
that's interesting.
The median fee paid by a clinical lab is substantially less than the average of these numbers. Dick's looking at me like I got my math wrong, but like maybe I forgot since I retired. But so my comment is just that this is very useful information, and while asking for it may have been onerous, our labs are spending a lot of money to comply.
Dr. Corrado, I'm sorry.
I just want to point out that one of the differences, because I looked at the differences between the labs and Askeladd Lab, but Askeladd Lab provided the numbers for 10 years, and the labs were only asked to do for 6 years. So I think that's a large difference right there.
That's what we were asked to do.
Right.
But when you take Askeladd's numbers and divide by the number of events that they reported, so you come up with an average application fee, it's very different.
And I would say the other thing I wanted to point out that relates to that is remember that the laboratories, a lot of their fees are based on the number of disciplines. So laboratories with more disciplines end up paying more, both for the inspection and sometimes for their annual. That's more based on staff. And maybe that's partly why there's a difference in price with the clinical, because I would assume in theory that's more like one section, or I don't know.
It's by revenue in that situation. And it's understandable that it's cyclical. It's here that you pay for an on-site survey, you're paying substantially more, which is interesting because some labs reflect that, and other labs seem to show the same number every year. So, no. There are some unusual observations that could be made, but very interesting information.
Just recall, remember that in 2006, we instituted mid-cycles,
Right.
which is why you have the increase in the latter years.
I just want to make a small correction for the ABFT accreditation course. That is not calendar years, that is fiscal years, 2000 to 2011.
Oh, okay.
I have a question about how the numbers were compiled. So, ASCLD, did ASCLD Lab ask our labs how much they were paid and got some data from them as to how much they were paid, or did ASCLD just look at its own paperwork and come up with these numbers?
ASCLD was asked separately from the lab directors, and they came up with their numbers. The lab directors gave their numbers to OFS, and we compiled those charts.
Right. Well, is there any way for you to look and see whether your numbers are the same?
Well, they're not, but you have to recall, there's sometimes when a laboratory might have paid, in December for a double year or something. I think there's a lot of that. We don't know how the money was tracked and paid for. These are just the numbers we got.
I also wonder if some labs, I don't know, and maybe Kathy does, if in addition to the application fee they paid and the survey costs they paid, may have included the costs of their personnel in conducting these activities. There are a couple of labs that I suspect.
No, we asked them just to give accreditation costs, annual fees. That's it.
I know a lot of clinical labs would give you their personnel costs as well.
We asked about that. We asked, should we provide calibration? No, we were told by DCGS only include what you paid for your inspection and your annual fee.
Because if you had tried to include everything that it was accreditation, that it would have been.
Well, I think that's very good, because what it means is that we asked our labs for data on what fees they paid ASCLD, and ASCLD is supposed to be telling us what fees they received from our labs. And since we're comparing apples and apples, I'm just curious to see whether they really do compare accurately. They should, right? Am I missing anything there?
But they're not.
Well, these are the numbers we received.
So the number is different, so it's not exactly.
We didn't get from ASCLD Lab by year. We got from the labs by year. ASCLD Lab gave us the total over 10 years and told us that it was $27,000 for surveys, but they did the lab 4 times. But they didn't tell us in which year and which amount which year. They told us they'd had applications to the lab each of 10 years, and the total was $20,000. So you can take an average, but you don't know which year the lab paid which fee, versus the lab that said in 2010 I paid X for surveys, X for PTs.
Well,
so
that was...
No, you did. ABFT gave it to us differently.
That was our
gave,
understanding.
Right.
That's what the...
But ASCLD gave us a total over 10 years. So we can't break out the numbers and know if the numbers are the same.
Right.
Any further discussion?
I think it would be worthwhile suggesting that prospectively on a biannual basis or whatever, we continue to update this information. I mean, if the labs know now that every 2 years they need to report this information, or every 5 years, I don't care what the cycle is, but having gone to all this effort, I don't think we should lose the trend. Because I think legislators and representatives and county executives want to know whether their labs are spending more or less, or is this costing too much? Is it worth the next question will be, is it worth the investment? But having the numbers can help.
Yeah, and that's why I would really like to know, if it's possible, what this stuff was for. I'm actually surprised to hear from Ann that this looks like it's more money than medical laboratories would pay for similar services. And if that's true, why? If the clinical laboratories, for example, are getting these surprise inspections or looking at data, in different ways, then ASCLD is doing it. I think it would really be a worthwhile exercise to figure out, what it is we're spending the money on. I mean, I'm surprised to hear it because when I took a look at these numbers, I thought it was low. But then again, I must concede I don't really have a good idea of what all these inspections and accreditations cost and how much we're being charged. Are we being charged by the hour of inspectors? Are they being charged a lump sum fee? Is it travel expenses that's really the issue here? And per diem, I have no idea. It would be useful to know.
Yes, Doc.
I would call your attention, if you go to the ASCLD Lab website, their September 2011 newsletter actually speaks to their share cost fees and how they came about and what the fees are based on, and that might at least give you a starting point as to what the fees are used for.
Well, maybe you could help me because you're the consumer. What are those? What is that? What are we paying for here?
Well, you pay for different things.
Paid by the hour? Are they paid by a set fee? Or is the primary expense travel? I mean, what is it, Dr. Carrata?
There's both. So there's an annual fee that you're paying for all of the support that ASCLD Lab requires, because remember, we provide them with all of our proficiency tests. Every time we have a proficiency test, it goes to an ASCLD Lab Proficiency Review Committee, and they review those and determine if there's issues and then contact the labs if there's issues. If we have corrective action, it gets sent to ASCLD Lab. They review the corrective action and follow up if need be. We also send our annual reports, which are quite extensive, and they have to review those and see if we're in compliance. In addition, in the ISO system, they come out every year for a surveillance audit, so they do send someone out. So there are the travel costs with that. When you have the full audit, they send 5 or 6 inspectors, depending on the number of disciplines. And in that situation, they charge you. I mean, basically, their fees are based on the number of proficiency tested staff you have annually, as well as for the annual when they come out and do the inspection, it's based on the number of disciplines as well as the number of staff. So if you have, say, New York City OCME has so many staff, they would have to send a lot more inspectors. So they charge you based on the number of inspectors that they have to send. And obviously, that's all put into a single cost for the inspection.
On pages 27 through 29 of the program overview that was shared with you in your material from ASCLD Lab, there's a listing of the various fees that they charge, what the fees are for, what you get back for them, which also might help inform things. Is there any further? Yes, Dr.
Where was that? Mr. Chairman, where exactly?
Page 27 to 29.
Okay. Thank you.
Is
Dr. Jenny.
DCJS funding accreditation in any way?
No.
Have labs complained about the cost of accreditation?
Okay. Indirectly, we provide aid to lab money through laboratories. To the extent that we provide aid to lab money, it is quite probable that the laboratories use some portion of it for maintaining accreditation.
Is that aid trended in any one way, up, down, state level?
Our aid to lab money's gone down considerably.
So in fact, labs may be taking on more of a burden of accreditation fees.
One way or another, they're losing revenue from us. It's been cut in the last several years.
Are these numbers of interest or value to DCJS in making a case to perhaps assist laboratories in the funding of accreditation fees?
The information is extremely useful, to be honest with you. To be able to crosswalk it, I actually had the same take on it that Mr. Scheck had, that it was actually less than I expected until I heard Dr. Willie say it was considerably more than what she thought.
I have to say, my gut reaction was this was low.
Right. I mean, the median fee paid by all, the over 1,000 clinical labs that pay fees to the state of New York. And they get full accreditation, PT, inspection, personnel. It is a unique system. Is under $10,000.
Yeah, and if you take a look at the ASCLD report, they said 10 years worth of doing this, they took in $1,300,000. So that's $130,000 what they're reporting for 22 laboratories, $130,000 a year on average. I mean, it's gotten a little bit bigger the last couple of years because of more disciplines under review and because of the international standards.
Now, I do think the clinical number is probably not a fair basis because the very large commercial labs pay extraordinarily higher fees. And I don't have any way of knowing the volume. I mean, these are regional labs to a large extent. Are they more equivalent to a small commercial lab, or I don't know. And those, understand, in the clinical world, the fee can go up to well over $1 million a year. So,
any further discussion?
Well, it looks like from the pages that you've directed us to that it appears as though the primary driver of costs here are the number of proficiency tests, no?
The proficiency tests are not purchased from ASCOD Lab. That's a separate cost.
I understand that, but the number that they have to review. I mean, what is?
No, it's considered the number of proficiency tested personnel. So basically, the number of scientists that are in the laboratory.
Right? Isn't that the key component of the fee structure on their website? That if they come to a lab, the first determinant is how many proficiency tests do we have to look at and personnel. And then they have a sliding scale based on that.
No, that's mistaken. It's the number of staff that take proficiency tests. In other words, the number of scientists that are performing analysis and reporting out. It's the number of staff, not the number of, the way they determine if a staff is a scientist is if they take a proficiency test. In other words, if I have 10 administrative people that file my files, that's not going to increase your cost. They don't care because they're not looking at the person that's putting papers in a folder. They're determining your cost based on the number of scientists you have performing analysis. That's where that proficiency test comes in. What number of people in your lab take proficiency tests?
So if your lab has 10 people taking proficiency tests and my lab has 40, I pay more than you.
That's correct, because the number of cases and the number of things they have to look at is higher.
Any further discussion? All right, hearing no further discussion, the last piece of business under new business is, actually that was the last piece of business and new business. Now we'll move to old business. I'm sorry, the chart of external investigations is in your materials. We will discuss that if at all in executive session. Old business. I sent a letter to the DNA subcommittee asking them for an opinion on behalf of the board on August 24th, and you should have received as loose materials at your seat today when you arrived a reply from Dr. Ballantyne, chair of the New York State DNA subcommittee. Questions? we will recall or not specific loci should be cited, or whether the kit used for the analysis should be utilized. The DNA subcommittee unanimously agreed that the use of the kit designation was, quote, preferable and desirable, unquote, although they did not preclude laboratories from listing the loci if they wished to. Any discussion?
Get a response to that?
Yeah.
I only assume, I don't know that this kit designation, because if it's the name of the manufacturer of the kit, that's not sufficient. If it's the name of the manufacturer of the kit, the model, the lot, then yes, a third party could go to the website of that manufacturer and download the primers, which therefore gives them the loci. So Kathy's nodding her head yes, and so, okay, thank you.
They actually include the alleles.
Any further discussion?
Yeah,
I think there's a misunderstanding. I'm sorry, Sean, but it's my recollection that our concern with OCME was not whether you list the loci you tested as opposed to the kit that you used, but rather the failure of OCME to identify the alleles observed, okay? In other words, there are many laboratories around the country, public sector laboratories and private sector laboratories, that when they do a forensic DNA test, they'll include a table. And the table will have, will list the markers. It will list on the left-hand side the samples that were tested, and then the boxes will be filled in with the alleles observed for each sample at each marker. That way both sides will know instantly what was actually seen. OCME doesn't do that, unlike many other laboratories around the country, and that's the matter that we were all concerned with. So perhaps what you might want to do is write another letter to Jack asking that question, but I would ask you, if you do that, to at least show him some of the other reports and put it in that kind of context so he can comment on it accordingly. And I apologize if there was a misunderstanding.
Any further discussion?
In other words, for instance, the way OCME writes a report, one can't even tell. Let's say they ran 13 markers. We don't know whether or not they only got results on 6, 9, or all 13. We don't know those things. You can't tell that from their reports, whereas many other ASCLD lab accredited laboratories provide much more information to the court and to lawyers.
Dr. Prince, do you feel comfortable speaking about this? Thank you.
I remember we had a discussion and we did explain that the accreditation does not require us to list.
Sorry, Dr. Prince, could you speak closer to the mic because we can't hear you well over here.
All right. I remember explaining this because it came up. The original finding actually was not related to us not listing the alleles. The finding was related to the header in the report. But I did explain that we are required to have in the report results and conclusions. So we do have the conclusions, we list all the samples, and if there is a statistical evaluation, we will also list on how many loci the statistics is based. So it is true we are not listing every single allele call. We had made a decision when our case load went up. We were issuing a higher volume of reports, that it made the technical review too time-consuming. We had instances of typographical errors in the allele tables that caused delays in the reports, caused us to issue amended reports. We had made the decision to take the tables out and only list the conclusions, while all the allele calls, of course, are still in the laboratory notes. That is true.
And the laboratory notes are available
Yep.
to the prosecution and defense.
Yes, we routinely copy all the notes. We literally copy 300 case files a month, at least.
You routinely give the laboratory notes to the defense?
We give it to the prosecution, and they are required to hand it over to the defense. It's my...
No, well, I'm not sure that, maybe the prosecutors can help us here. Is it a routine practice that at the same time that the report is given, that the underlying notes and electropharograms and everything else is also given to the defense counsel at the same time?
What happens typically is
I think you have to talk into the microphone, so.
What happens typically is that the
Can you all hear her?
Yes.
Melissa from Manhattan DA's office. What happens typically is that the report is issued first. The prosecution gets a copy of the report. We turn it over to the defense as a matter of course, and we turn that over when we receive it. The bench notes, the entire lab file, typically comes sometime later from the OCME because it has to go through the technical and administrative review process. When we receive it, we copy it, it's a certified copy, and we turn it over, in a matter of days to the defense. And it is also my understanding that if the defense requests the report from the OCME directly, they will get the report. If they request the laboratory file with all the bench notes, they will get that as well. It's not been my experience that OCME picks and chooses which side they are going to give the report to.
Has it been your experience in all Manhattan cases involving DNA that routinely you give over the laboratory notes, not the first report, the laboratory notes that you get several days later as a matter of routine, that DAs in individual cases in Manhattan in the years 2009, 2010, and this year, 2011, do not object in court to the defense receiving, upon request, those underlying notes? No DA does that.
It has been my unvarying experience that the case file that the prosecution receives from the OCME, which contains the contemporaneous lab results, which contains the electropharograms, which contains the editing sheets, which contains every note of every step of the process, that every page of that the prosecution receives, with the exception of some redactions having to do with victim name, address, things that may be included in police reports that are part of the file, gets turned over to the defense. That's absolutely been my experience.
Just one question, just for clarification. Does your office turn that over automatically, even where defense attorneys don't ask for it?
Absolutely. As part of the discovery requirement, we turn those over so that there is not a single piece of paper emanating from the lab that the prosecution has that does not also come into the hands of the defense.
Do you know what one second. Can you just tell us about the experience upstate?
Yeah, Melissa, just to add to what happens in Manhattan, upstate, at least as far as I'm concerned, we have the exact same procedure that you guys follow in New York. as far as I'm concerned, upstate, at least in the Capital District, typically the same procedures are followed, regardless of whether the bench notes are asked for or are not asked for. They're turned over with the same redaction relative to victim information.
I'm sorry.
Can I ask who was just made that statement and what county they're from?
Saratoga.
District Attorney Murphy from Saratoga County. I think I may have inadvertently cut Mr. Scheck off. Did I?
No.
Okay.
A question. Is that the same practice throughout the state?
To the best of the prosecutors around the table, yes.
Well, could you do this then, make so we can formalize Judge McQuillan's question, if you will? Can you take it upon yourself, Sean, to inquire with each of the laboratories that are accredited to do forensic DNA work, and with each of the prosecutors in the state by letter, whether or not they have the same policy and practice as Niagara and New York County, to wit, do they automatically, without even getting a request, turn over the bench notes on the individual test to the defense attorney?
No. Is that it? Turn that over to the Justice Task Force.
They are. The Justice Task Force is reviewing this right now.
I'm asking for the commission. I mean, the Justice Task Force is making that written inquiry for you?
They're not making it for us, no.
They're making it for
Well, what inquiry is the Justice Task Force making specifically?
Because they're reviewing forensic issues in order to make recommendations.
Well, I don't see, if you can't be specific about that, and they're just reviewing the general area of discovery, this request is a little bit more specific, because we've had representations here today from the Manhattan District Attorney's Office and from Mr. Murphy up in Saratoga Springs, or Saratoga County, that this is the procedure they follow, that the underlying bench notes are turned over to defense attorneys even when not asked. So we're simply asking, can we, as the commission, find out from the laboratories if they do this as a matter of course? And when I say this, do they turn over the underlying records, the bench notes, and all of the other underlying DNA material to the defense, not to the prosecutor, to the defense? One times when you ask this question, as we did a few minutes ago, to the individual who's sitting to your right, Sean, the answer, Dr. Prince. A lot of times when you ask this question, and Dr. Corrado did this several meetings ago, when she exclaimed, there's no problem with exculpatory evidence, we turn it all over. But the answer when you probe is, we turn it over to the prosecution, not to the defense. So that's what I'm asking. Can we, the laboratory directors, do they follow this particular procedure? The other way to do it, or in addition to that, is for the commission to send a letter to the New York State District Attorneys Association, to Ms. DiFiore, who I think is this year's chair, and ask her what is the policy of the district attorneys in the state of New York, county by county, in turning over this material to the defense without asking.
Well, I don't know what, I certainly, the commission can ask District Attorney DiFiore what the policy of the 62 individual district attorneys is, but I suspect that that would be a lengthy response, and I think it would depend upon a case-by-case basis in some counties. I mean, we tend to have in Saratoga County, which is just one small upstate county, a relatively open discovery policy, which might be different from other counties. I'm only reporting what we do in Saratoga. So I'm not sure that District Attorney DiFiore would find that an easy task, or the responses to her inquiry would be comprehensible in terms of a written response. I think
here's just so you all know that this is first we should just state for the record that this is not a trivial inquiry, as I'm sure our colleagues in New York County would recognize, because they take the time to make sure that all these things are turned over. Because the problem is, given the decision that the OCME has made with respect to the limited information that goes out in its initial reports for administrative reasons that Dr. Prince has explained, there still is the potential issue when you look at the underlying data for all the different loci that even if OCME, for whatever reason, has decided not to report a statistic because not enough loci were identified as matching, so to speak, to give a number, the defense may very well want to argue that there has been DNA identified at a particular loci that is different than that of the defendant, or may lead to may lead to a particular individual who they are going to say really committed the crime. So, and then there's issues of quote-unquote allelic dropout. So these are not trivial matters. And the reason we're asking this question in the first place is that a number of private laboratories over the years and public laboratories have issued reports where they'll list every single allele, and they'll even put little asterisks in them saying, we found something here that could be considered an allele, but we're not considering it an allele because it's below our RFU threshold for reporting something out as being real as opposed to an artifact. So that's all very valuable and useful information that prosecutors and defense and courts need to know about in a particular case. So it makes perfect sense that if you're not going to have a complete report, there is some assurance that all the data is being turned over, even without request. Now, let me just talk to Ms. Bianchi's concern. I think that this is peculiarly the responsibility of this body to make sure that we know what the practices are of all the labs and all the district attorney's offices with respect to the disclosure. Because it certainly seems to me that if you're not issuing a full report, then you should do what we're being told is done in Saratoga County in New York City. And the reason why it's got to be this commission's responsibility, although we might work in tandem with the Justice Task Force, is that in other matters with the Justice Task Force, with respect to, for example, videotaping of interrogations and training procedures for how police departments do interrogations, we repeatedly asked on the Justice Task Force to find out what the training materials were and what the police manuals were in various different jurisdictions, and we never got that information. So the Justice Task Force has saying that it's... I'm sorry?
We don't have any jurisdiction over the district attorneys, so although we can ask for it, whatever we get back, we get back. We can certainly ask the lab directors.
I feel certainly we can ask the lab directors, and I would suggest that in the spirit of making sure that we do everything in ways that promote high, real quality assurance, because, you know, the alternative is if the district attorneys are not doing this, then, and I trust that they are, but if they're not doing this, then we have to change the way that labs issue reports. So, you know, you can't have it both ways. I think, however, that if the labs tell us how they do it, the district attorneys are sent a letter asking what their policies are, then we can be assured that a best practice is being followed by everybody in the state, and we'll all be on the same page. But that's not, and while I think the Justice Task Force should appropriately look at this, I know from experience that we cannot count on that entity to necessarily get all that information. But we can count on this one to get it. And we have jurisdiction.
So we have a request that we send a letter out to the 62 district attorneys. Yes, district attorney.
Let me just talk about that. I, like Jim and like Melissa in Onondaga, I don't like to track cases twice. I give the information over. But we're way ahead of the things in the DA's Association. we're way ahead of the Justice Task Force, with all due respect. We issued protocols on videotaping well over a year ago. Doesn't mean everybody's going to follow it. Doesn't mean they can't follow it. And I'm not sure that we as the Forensic Science Commission have the jurisdiction to micromanage discovery procedures in each county. Defense lawyer for 5 years upstate New York. Some counties you get absolutely nothing. Some counties you get an open file. I prefer the latter, but I can't tell a colleague in Herkimer or Cayuga or Cattaraugus County that, look, this is what you have to do. He or she have their own constitutional obligations regarding exculpatory material. But what we are doing in the Best Practices Committee of the DA's Association is addressing the ethics of both lab directors, lab personnel, and district attorneys. And I'm more than happy at our next meeting, which will be in January, to bring this issue up and discuss it at length and suggest what I think is the right procedure. But I don't think that sending a letter to 62 DAs, how do you handle discovery is going to complicate this jurisdiction.
Bill, we can send a letter to the District Attorneys Association with the request that all 62 district attorneys respond. But just to be clear about this, the issue is, would labs be required to issue reports, which Dr. Prinz is, for example, saying are too extensive and would cost too much money and would have typos and things like that that they later have to correct, versus the kind of reports they issued with the assurance that the entire file is being turned over to the district attorney and then in turn to the defense. See what I mean? In other words, a trade-off here. We don't necessarily want to burden the laboratories with doing more extensive reports if, in fact, all the data in a timely fashion is getting to the defense. We can't know empirically whether that's going on unless we know that the district attorneys are following those practices. So it's really an empirical matter. It's not a question of telling district attorneys what they ought to do. It's a question of telling crime labs what they ought to do. And it's okay with me if the crime labs are following the procedures that they've outlined here, as long as we have assurance that the information is actually getting to the proper parties in a timely fashion. Is that clear? Does that make sense to you? In other words, we do have authority to tell the crime labs what to do. We don't necessarily have the authority to tell the district attorneys what to do. But if the district attorneys are, as a practical and as a matter of policy, immediately turning over all the DNA results, the underlying material, as soon as that comes in, then we don't have to, then the requirements for the initial reports don't have to be so onerous. So we need to know that information.
We're not asserting any jurisdiction here. All we're doing is a public commission of the state of New York is sending a letter to an organization that represents the district attorneys and asking for a piece of information that is helpful and necessary in our deliberations and in fulfillment of our statutory function. If they do not wish to answer on the grounds that this commission is trying to assert jurisdiction over them, they will say so. If they do wish to answer, then it's a fairly simple process. The letter to Ms. DiFiore simply asks in a one paragraph that she ask her 62 district attorneys, do you do this? And it requires a simple response. Yes, I do it. No, I don't. Yes, I do it on a case-by-case basis. That's it. That letter can be written in 10 minutes. So I think it's an important thing for us.
You want to put that into the form of a motion? We'll get it seconded. We'll put it up for a vote.
I'll make the motion.
Yeah.
The motion is that we send a letter to all the labs and lab directors requesting of them that they tell us, have they, as a matter of policy, turn over all of the underlying reports, memoranda, analysis, CDs, whatever is associated with the DNA file to the defense, asked or unasked. and that we specify in the letter that we are not asking them if they turn it over to the prosecutors. And secondly, that we send another letter to the District Attorneys Association.
They won't even know who the defense is.
I'm sorry?
They won't even know who the defense is.
Okay.
I think you need to focus it.
No, Marvin, as a friendly matter, I think the question you want to ask the crime lab directors is, do they have a policy and practice of turning over the bench notes on each case, either to the defense or to the prosecution, either one. And then you have, and if so, they'll tell you what the policy is, and when that's done. And then we write a separate letter to the prosecutor simply asking them,
what is their policy?
As a matter of policy, is it like New York County where they will, even without a request from a defense attorney, share the bench notes in a timely fashion after they get them? And then we can put two to two together. And that'll help us because we'll know, as Barry pointed out, if that's being done, then there is really not as much of an incentive for this commission to require that more content go into the original report than that which Dr. Prince is describing. If, on the other hand, we learn that, unlike New York County, a substantial number of the counties don't do what New York County is doing and don't do what Saratoga does, then we may have different prescriptive suggestions. It's plain and simple.
So do we have a second to the motion that Mr. Neufeld has?
Perfect.
Is this just for DNA labs?
This is for DNA labs.
Just for DNA.
Just for DNA.
Is there a second? Mr. Scheck seconded it. Any further discussion? All those in favor of sending a letter out to all the DNA labs asking the lab directors about their practices in turning over all of the bench notes in every case in addition to the reports from the DNA cases, please indicate your support of that by saying aye.
Aye. Aye.
Opposed? Please raise your hands in the city. 2, 3, 4.
Abstain.
Abstain. 1, 2. Mr. Fitzpatrick, yes, sir. Are you abstaining or
Just a nose?
no's?
You already got those.
Okay. So we've got 2 abstentions and
No, I was a no.
and no. Okay, so we had in New York City any no's? So it, did I get
2 abstentions.
2 abstentions, 4 no's, and 1, 2, 3. Could I see the yeas, please? Everyone raise your hand so that I can see the number. 1, 2, 3, 4, 5, 6. 6. Okay.
Doesn't carry.
Does not carry. Motion does not carry.
For writing letters, we need a certain threshold? Is that the opinion of council?
You need
to
Just
have,
for writing a letter?
You need to have a majority of the
you
quorum
need to
present.
have 7 people to pass that motion. So there was a motion.
So,
All right, well, if this helps, we're going to write the letter anyhow. I mean, it's we're going to write the letter to Janet and to the District Attorneys Association. Frankly, I'll write this letter to all 62 district attorneys.
And I'd
So,
also, I'm sorry, because we couldn't tell here, I'd like to know which people voted no to writing a letter, please.
All those that voted no, please.
I just got to pay attention.
Could you identify them by name on the record, because I can't tell from the distance?
Sure. Dr. Stajic, Judge McQuillan, District Attorney Murphy, District Attorney Fitzpatrick.
I abstained.
Abstain. Okay. That's the last of the business under, pardon me? Yes, please stay because you're next under laboratory disclosure item. Yes, absolutely. Kathy?
Yes, this is a corrective action that involved the reporting of false negative cases from New York City up to me. I just want to point out that this was discussed at the DNA subcommittee on their September meeting. And I also want to point out that this issue is still currently under investigation. It is in here in the open meeting only because it was discussed in the open meeting of the DNA subcommittee. But if there's any specific questions regarding personnel or sort of personnel action, I move this to executive session. But they are, Dr. Prince and Eugene Leon is here to actually give a brief overview. And like I said, if there's more specific questions you need, then we'll move it to executive.
You should have a July 7th letter to this effect in your packet.
So the situation is that we have a long-time employee that did hold the title to become a DNA analyst, and she was employed by the laboratory in late 2000. We decided to retrain her in 2009. We started the training process, and because of that training process, we discovered that, through technical reviews and through supervisory reviews, that there were just some deficiencies within case files that we needed to take a look at a lot more in depth. So the re-examinations were completed of the cases that she conducted while she was in training, and there were 2 cases that were incorrectly reported to our customers. As detailed in the letter to ASCOT Lab, DCJS, one of the cases where the original report indicated that no blood was found. Upon re-examination, we did find that blood was found. Unfortunately for that case, that's an assault case, and there were no exemplars submitted. So our laboratory policy indicates that no additional testing would be done. But we were working with our customers to see whether or not there are exemplars so that they can submit it so that we can see whether or not we can proceed any further with the analysis. The second case was a case where initially we reported that no semen was found. The stains were re-examined by another analyst, and now it's tested positive for semen. This stain was sent on for DNA testing, and no foreign DNA was found, that is. We're looking to see whether or not additional evidence from the case has been submitted, and we'll see. We will examine that, and we'll make an amended report once that analysis is done. Now, because of these 2 cases, because this employee has been in employment at the OCME since the year 2000, let me backtrack a little bit to give the timeline. She, at that time, entered the training program but could not pass the DNA oral examination. However, she was competent in she was able to pass her competencies in all the other analyses. Therefore, it was a decision at that point in time to have her hold the DNA analyst eligible title, but to do technician-related work. Up until 2009, that's when we decided that, or actually she came to us and said, she'd like to be retrained so that she can be a DNA analyst, and we proceeded to do so, and that this issue was discovered. So currently, we are going back to all of the negative cases that she's reported, that we've reported because of her examination. And we're retesting those to make sure that the results that we've reported were correct. We followed this line of investigation because the issue originally concentrated that we found on her was that she failed to identify the stains that were there. However, any positive stains that she had identified, that would have been sent through to another DNA analyst for DNA testing. So we feel that those cases are good as is.
Yes, Dr. Jenny.
So clarification. This analyst was in training for results or analyses where results were released?
Yes.
Yes. Why is that?
That is our practice. During training, a DNA analyst will work on some cases under supervision. Yes.
without review?
No, with
before
review,
release?
obviously.
Oh, with review.
They were
This is-
reviewed prior to release?
With,
Her results were reviewed
they
prior to
were
their
reviewed,
release?
yes.
So
But
it was a
since the
review
end-
that did not detect these two errors?
That is correct. Because the technical review does not involve going back to the examination space and opening up the packages again.
Would you continue to allow an unqualified trainee to perform analyses without parallel testing by a second individual in light of this problem having come to light?
So she was not unqualified in the sense that she had passed a competency test for this.
Not for DNA now.
Not for DNA, but for a sexual assault kit.
So she had
She had
passed her
passed a
competency for the serology
Portion,
component.
that's correct. What she was doing is, in essence, she did pass the competency, and she was examining the evidence and performing analysis on those that she was deemed competent. However, the portion that she was not competent in, which was DNA analysis, she was not conducting.
So these were errors made in the categories for which you had considered her.
Exactly, yes.
Yes.
And how many cases are you retesting?
We've queried to see how many cases she's touched through the years, and I believe that number came out about 400 or so. We had to wheedle that down also because, again, we're concentrating on cases that were reported as negative, so therefore that came down to about 120 and change cases.
So that's our ongoing corrective action is that we recalled 120 plus sexual assault kits from the NYPD property clerk, and all of those kits are being reanalyzed right now.
With respect to these cases, your letter indicates that you've been working with your customers to explain to them what you've been doing and keeping them abreast of the examinations you're doing. Who's included in the customer base?
Since I have to preface this with something, a lot of the cases that we test do actually not have anybody under arrest. So there is no suspect, nobody arrested, no defense involvement yet. So our customers, even for those old cases, are the NYPD and the 5 different borough district attorneys' offices. We are going to issue new reports on all of the reanalysis, and I have a commitment from the borough district attorneys' offices that in every case where there was a suspect and there was a defense attorney, that defense attorney will get notified and will receive the new report.
Now, with respect to the 100 cases you've narrowed this down to?
Yes.
Of the 120 cases, how many of those involved arrests?
I do not know.
Where you have?
See, our paperwork at this early stage is very incomplete. Sometimes an arrest number is listed, most often not.
And when you say you've secured an agreement from the district attorney's offices,
Yes.
is that throughout the state or just New York County, Queens?
Just
the
New
5
York City. Our cases all come from New York City, so it's 5 different New York City boroughs.
And all 5 New York City district attorneys have agreed to notify the defense attorneys?
Yes.
To let you notify the defense attorney?
No, we wouldn't have the names, contact information. We don't have that type of information.
Was that agreement, just because I'm a little hyper-technical sometimes, was that agreement that you secured from the district attorneys in New York City in writing, or is that just an oral understanding you have with them?
I do not have the agreement in writing, but I already have reviewed. I know there is a letter in preparation. So I know they're actively working on it.
Thank you.
Any more questions for Dr. Lean or Dr. Prince?
Thank you very much, folks. The next matter relates to the NYPD and to loss of drug evidence.
Yes, this is an update, and this incident also is closed by Accreditation Lab as of this past week. Last week we also had a October 11th letter from NYPD regarding Accreditation Lab was requesting more information about their administrative actions. That was sent to the New York City members by email this morning, and everybody else here in Albany got a copy. That's just a review of a further request from Accreditation Lab. And this is regarding the loss of drug evidence. This happened back in, I think, July of 2010. And the investigation is complete on both NYPD as well as with Accreditation Lab. And we have a representation from out of the NYPD to discuss further.
Everybody should have gotten the October 11th letter from the NYPD.
Everybody here in Albany, and I sent it by email to New York City by 8 o'clock this morning, so, I mean, to your emails. So hopefully you got it, because there's also another letter for executive session that was sent, but these were just updates.
Any questions about the NYPD matter for either Dr. O'Neill or for Commissioner Phil Pulaski? Any questions?
I'm just trying to picture this in my mind. I'm watching this bag slowly slide down into the trash. You know, and some defense lawyer's got to be watching this going, "Thank you, God." But do we know if it was the ecstasy or the marijuana or both?
It was actually the entire case from that precinct. It was whatever came from that precinct that night. So it was both.
Slide right into the trash. So, was any arrests of Department of Sanitation workers the following day?
Being discussed every year. You had trash containers in the
Same case. Same case. Yes. They're just reporting out on their internal affairs and the Queens County District Attorney's inquiries.
Another lucky bastard.
Just to recap for everybody, in case you haven't had a chance to look over the letter, that the finding was the evidence was accidentally discarded, but that they've adopted a new protocol where garbage containers will be inspected by a supervisor prior to removal from the garbage from the intake area. So if I hear no questions for either Dr. O'Neill or for Commissioner Pulaski, we'll move on. Gentlemen, thank you. Appreciate it. Right. That's the last bit of business we have before going into executive session. I need a motion to go into executive session as we may be discussing or will be discussing matters that could result in employee discipline. Dr. Corrado, seconded. Dr. Stick. All those in favor? Opposed? Okay. Yeah. We're back on in open session. I just wanted to tell everyone that the next meeting of the commission will be December 8th, 2011 in New York City. Can I, we took no action in the executive session. Can I have a motion, please, to adjourn? Okay, thank you, everyone. We appreciate your contribution and participation.